7 p.m., February 17th, 2025, Zoning Hearing Board for Cecil Township. I'd like to call this meeting to order. Approval of minutes for January 20th, 2025. Look for a motion to approve.
I'll make a motion to approve.
Second it.
All those in favor?
All those in favor?
Aye.
Aye.
3-0.
Yes.
At this time, I'm going to turn the meeting over to Zoning Hearing Board Solicitor Chris Volz.
All right, good evening, everybody. Before we get started, I'd like to introduce everybody. Board President Kara Sheridan is absent today. Instead, tonight we have Troy Gump, we have Alan Barney, we have Joseph Flaherty, alternate, and Ted Donald, also an alternate. We're going to begin tonight with the application number 2024-15 filed by Range Resources Appalachia, LLC, dealing with their substantive validity challenge. Mr. Donald has recently been appointed as an alternate. I think we'll have let's have a motion to appoint Mr. Gump as our temporary president, if someone would make that motion for the night's hearing.
I'll make a motion.
Okay, and a second?
I'll second.
Okay, all those in favor?
Aye.
Aye. Aye.
Okay. Procedurally, Mr. Barney has recused himself from this matter. So I think we should have a motion to appoint Mr. Ted Donald as a sitting member for the board for this application number 2024-0015.
I'll make the motion.
Second.
All in favor?
Aye.
Aye.
Okay. So when we left off last month, in addition to the applicant Range Resources and Cecil Township, the following entities had entered their appearances. The Georgetown Estates Townhouse Association, represented by Joshua D. Brown, Esquire. Michelle Stonemark, a resident, represented by Dwight Ferguson, Esquire. Sarah Martick, resident, represented by Ethan Story, Esquire. The Clean Air Council and Center for Coalfield Justice, represented by Evan Diamond Johns, and several residents, Michael Monaco, 3 State Development Company, Bruce Gazvada, Jeffrey Dressler, Linda Capel, and Patricia and Timothy Walker, residents, represented by Bernard Matthews, Esquire. They were given conditional permission to participate with the understanding that any presentation they will make will require evidence that they have standing to appear before the board. Also last month, Cecil Township filed a motion to dismiss the application. The board announced that it would take that motion to dismiss under advisement. Since that hearing, a motion to dismiss has been filed on behalf of Michelle Stonemark. In addition, Georgetown Estates Townhouse Association and the Center for Coalfield Justice and the Clean Air Council have each filed a motion to join in the township's motion to dismiss. As we stated last month, we will take these and consider these arguments in these motions to be timely raised, and we'll take them under advisement. For tonight, Range Resources will present its case in chief, or will begin to anyway. They are represented by attorney Kimberly Brown, and she will begin their presentation tonight. Since we have so many interested parties here tonight, after each witness, the other parties, through their attorneys, will be permitted to question the witnesses. We will go in this order. First, the township, led by Gretchen Moore, Esquire. Then Georgetown Estates, via Joshua D. Brown. Michelle Stonemark, by Dwight Ferguson. Then Sarah Martick, by Ethan Story. Then the Clean Air Council and Center for Coalfield Justice by Evan Diamond Johns, And then finally, the residents, Michael Monaco, Three State Development Company, Bruce Gazvada, Jeffrey Jessler, Linda Capel, Patricia and Timothy Walker, by Bernard Matthews. We do ask, since there are so many people, that we not repeat questions that have already been asked by prior counsel so we can move this forward. With that, we'll turn it over to the applicant.
Mr. Volz, before we do that, one thing I think has to be clarified. You said that the objectors were given conditional permission to participate pending proof of standing and jurisdiction or standing. Isn't it also true that Range is only given conditional permission to present this matter pending the board's determination of jurisdiction and standing, since everyone here has objected to their standing and they've made no proof of standing?
No, I mean, I think we stated we will take that under advisement, and as part of our determination, I think standing has been timely raised. I think ripeness has been timely raised by the parties, and that will be part of our adjudication. I do think that some of the facts and evidence will be the same that go with their standing and their ultimate challenge. So that's why we're going to let them, but to your ultimate point, that yes, we could make a finding that they don't have standing to bring this claim, and that part of their burden of proof will be to demonstrate those factors, that they have a right to bring this application.
Thank you for that. And we do have 3 additional motions to dismiss that were submitted while joining in the position of the township. They are also supplementary with regard to some of their arguments. So these are matters that the board has not yet heard to know whether they should or should not be deferred to a later date. Waiting until this and maybe a subsequent or several subsequent hearings to render a decision as to whether or not this board has any authority under state law to even hear this challenge is a mistake, because at the end of this or several hearings, there's some things this board will still not know. So for example, you still won't know who the landowner is, because in the last hearing, Range admitted that they have no pending application and that this challenge appeal applies to no particular land. So we can go through hours and days of hearings, but you'll still not know who is even asking for this challenge.
Well,
because we won't
sorry
know
to
who the
interrupt you, but I
landowner is.
think you're getting, the cart ahead of the horse. Part of their burden with establishing standing is to show that they are a landowner and that they have standing to file this appeal, this application.
Done that. They've
So-
already conceded that there's no application.
Again,
Like
Ms.
site.
Brown is an attorney. I don't know that she's qualified to testify, and I think we were just doing some preliminary things. So I'm going to allow them to start their case in chief, and we will hear your arguments in due turn.
Okay, thank you.
One other point of order before we get started, and this is a different issue, and I do think it speaks to some due process concerns that I have. You mentioned this evening that the parties over here, other than the township, have conditional standing to participate. And last week, I believe you said that should you decide at the end of this that they don't have standing to participate, then you were striking their questions. So I think that has huge due process implications. So if you are inclined to wait on a decision on standing for the rest of the people on this side of the table, I would ask at the very least that you allow, without us having to ask each time, every party on this side to incorporate each other party's question, so that, to your point, there aren't duplicative questions, and that if one party you should find does not have standing, that doesn't risk that their questions are then lost, which I think would be unfair.
Okay, that's a fair point. We'll take that under advisement. And Ms. Brown, please proceed with your case in chief.
Thank you. Good evening. There are 2 preliminary issues that I would like to address with the board before we begin presentation of our evidence. One is, and this is directed to the comments from Mr. Volz regarding who the conditional parties were. We agree as to the list that you provided. However, I would like to note for the record that there was an attempt by counsel for Ms. Stonemark to apparently enter an appearance on behalf of a party who was not here at the beginning of the proceedings. And that, I believe, is Mr. Stonemark, Josh Stonemark. Range objects to his participation as being untimely. And to the extent that you want argument on that, I'm happy to proceed with that. But I believe that he was not here. Ms. Stonemark only entered an appearance on her behalf, saying that she was going to have counsel representing her at future hearings. And we understand that her participation here is conditioned upon the zoning hearing board determining whether or not she should have party status along with the other individuals separate and apart from the township who are seeking party status. But Range objects to any additional parties beyond the parties who sought party status in January from seeking party status at this time. And the motion attempts to do that on behalf of Mr. Stonemark. I believe the first name is Josh, according to the submission by Attorney Ferguson. We'd like to note for the record that we believe that that attempted party status entry of appearance is untimely, given the amount of time that has passed since Range filed its submission in late December.
How would Range be prejudiced in any way if Mr. Stonemark was permitted to participate alongside with his wife if they have the same attorney?
I don't know that the standard, I don't believe that the standard is whether or not Range is prejudiced. I believe the standard is whether or not the party has timely entered their appearance under the MPC, and we believe that they have not.
Okay. We'll take.
I'm happy to move forward.
Yeah,
though.
we'll take that under advisement.
Thank you very much. There is one additional preliminary matter that we would like to raise to the board's attention. As the board is aware, a fair trial and a fair tribunal is a basic requirement of due process. Any tribunal permitted by law to try cases and controversies must not only be unbiased, but also avoid even the appearance of bias. That's the case law that applies in the Commonwealth, and I believe, Mr. Solicitor, you're aware of the decision McVeigh versus Zoning Hearing Board of New Bethlehem Bureau, which is a 1985 Pennsylvania Commonwealth decision that affirmed a finding of bias where the Zoning Hearing Board members had signed a petition opposing the land use in question. Consistent with the principles set forth in our Commonwealth Court, no man is allowed to be a judge in his own cause. Similar fears of bias can arise when, without the consent of other parties, a man chooses the judge in his own cause. Those are words from the Pennsylvania Supreme Court, our U.S. Supreme Court, Caperton versus A.T. Massey Coal Company, a 2009 decision, where the judge was required to recuse from a case against a significant donor to the judge's election campaign. The township's appointment, with due respect of Mr. Donald, to decide a pending matter after the zoning hearing board chairperson has already recused violates Range's due process rights. This is an adversarial proceeding between Range and Cecil Township, in which the zoning hearing board serves as a quasi-judicial decision maker. These due process principles apply. Allowing the township to essentially choose the judge in its own case, which is what has happened here, by the appointment by Mr. Donald by the Board of Supervisors of Cecil Township, is improper. And it violates due process. While it's generally true that in every substantive validity challenge before the zoning hearing board, the municipality has appointed the board's members, the circumstances here are materially different. Ordinarily, the township makes its appointments before a dispute arises. Thus, there's no appearance that the appointment has been made with a particular issue in mind. Here, by contrast, the township's Board of Supervisors were in active litigation with Range when they appointed Mr. Donald to the board. The Board of Supervisors thus had every incentive to appoint someone whom they believe would take their side on an issue that has generated significant local controversy. At the very least, this raises an impermissible appearance of bias. Also, Rage's understanding is, although we have not been able to confirm this, that Mr. Donald is a resident of the Traditions of America, a Cecil development which has spoken out in favor of extended setbacks like those challenged here. And during the hearings leading up to the township's adoption of ordinance number 9-2024, nearly 200 residents of that community submitted a petition supporting 2,000 to 2,500 foot setbacks from residences for, quote, fracking activities, end quote. And a law firm representing the development submitted a formal comment letter on May 1st of 2024, encouraging the Board of Supervisors to extend the setback then under consideration from 1,000 feet to 2,500 feet. Mr. Donald's appointment taints this proceeding with the appearance of bias. This matter should proceed without his participation, and the failure to recuse Mr. Donald at this time risks a reversal and increased cost for the township upon any judicial review of a decision adverse to Range. Therefore, we request that Mr. Donald be recused.
Ms. Moore?
Yes, Mr. Solicitor, as you know, under the MPC, certainly the township can, and in this case, needs to have a second alternate. Their plans to have a second alternate for this particular board were in place way before the filing of this particular lawsuit. And if we are going to have a mini hearing on the recusal of Mr. Donald, then I would suggest we actually have a hearing with some evidence. Obviously, as I said last time, every resident here is entitled to his or her opinion on any of these matters. To demonstrate bias is something wholly different than having an opinion on the matter. Even if he has an opinion, I don't know. We haven't heard anyone testify as to this particular issue. But certainly what Ms. Brown said this evening does not raise anything to the level of what would require a recusal in this case. Thank you.
Attorney Brown, is there any evidence that you possess regarding Mr. Donald making any statements about this application, about setbacks, or is it solely limited to the fact that he was appointed by the township and that he lives in the association?
It's based on the arguments that I raised, Mr. Solicitor. We do not have any additional evidence of direct bias by Mr. Donald, and our argument is that there is an appearance of bias, which is sufficient under the law to request recusal, particularly in a circumstance where the litigant who's involved in the proceeding is choosing essentially a judge in the proceeding.
Okay.
That's unheard of.
Mr. Donald, have you made up your mind about this case?
I absolutely have not. I have an open mind. I'm prepared to listen to the testimony and base my opinion based upon the facts that are submitted here.
Are you biased in one way or another towards or against the township in this case?
No.
Did you seek to be appointed by the township so you could rule in favor of the township in this case?
No, I did reach out to Don Ginesso 3 years ago when we first moved to the township because I enjoy being a part of these types of hearings and was a member of the Peters Zoning Hearing Board for a long period of time. So thus I wanted to become involved in the community when we moved here.
Do you feel like you need to recuse yourself from this matter because you cannot serve as a impartial, unbiased member of the board?
I have not made my mind up in any way, shape, or form, and I'm prepared to rule based upon the facts that are presented.
Okay. I don't see any reason for Mr. Donald to recuse himself. With that, you may proceed with your case.
A brief statement regarding Range's position in this challenge, and then we will call our first witness. The Fifth and the 14th Amendments to the U.S. Constitution circumscribe governmental interference with the right to enjoyment of property rights that are protected by the Pennsylvania Constitution. These rights are recognized by the Pennsylvania Supreme Court, including in the decision Exeter versus Zoning Hearing Board of Exeter Township, a 2009 PA Supreme Court decision. Pennsylvania law permits and encourages, quote, the optimal development of oil and gas resources in this Commonwealth. That's the Pennsylvania Statute 58, PA Stat, Section 3202, Section 1.
Yeah, I'm going to interpose an objection. I think this is the third time that Ms. Brown has been asked to begin her case, and that these legal arguments are going to be deferred to the end of these proceedings. I don't think anyone asked for an opening statement or legal arguments at this time.
Thank you. For the court reporter, what, is this a little better for you? I apologize, my voice is raspy, and I'll do the best I can, but please speak up again if you can't hear me. Range challenges the substantive validity of Cecil Township Ordinance Number 9-2024, specifically Sections 240-61.C5 and 240-61.C36 of Ordinance Number 9-2024, because the setback requirements constitute an impermissible de facto exclusion from Cecil Township of oil and gas development, which is a highly regulated and legitimate business use. We would like to offer into the record some preliminary exhibits. Specifically, Exhibit 1. Exhibit 1 is the December 27th, 2024 cover letter with ranges challenge to the ordinance, specifically Cecil Ordinance Number 9-2024. Exhibit 2 is Cecil Township Ordinance Number 9-2024, which was adopted November 4th, 2024, and is the subject of Ranges Challenge. Exhibit 3 is Cecil Township Ordinance Number 10-2024, which was also adopted on November 4th, 2024, and is partially the subject of Ranges Challenge, as well as background exhibits regarding prior ordinances that were in effect prior to the ordinance that is the subject of Ranges Challenge. Exhibit 4, Cecil Township Ordinance 9-2011. Exhibit 5, Township Ordinance Number 10-2011. And finally, Exhibit 6, which is the Cecil Township Oil and Gas Overlay District, 500 feet from structures and 2,000 feet from schools, which is the overlay map, which is referenced in Exhibit 5. We would like to offer those into evidence.
So the only objection I have is to Exhibit 3 and 5, and that is to the extent that the substantive validity challenge filed by Range Resources is only to Ordinance Number 9 of 2024, so I don't see the relevance of Ordinance 10 of 2024 or 10 of 2011. Other than that objection, I have no objections to at least 1 through 5.
If I may respond, Mr. Solicitor.
Yeah, that's fine. I believe it's 1 through 6, though, Ms. Moore. Do you have?
The presentation on 6. Is 6 the
6 is the map.
overlay map that was existing prior to the current map?
It is.
I have no objection to the extent is a true and accurate copy of Cecil Township's zoning map, but I do have the same objection as to the point that Range did not challenge ordinance number 10 of 2024.
Ms.
And
Brown?
the challenges are to which exhibits? So I'm clear.
Exhibit 3, Exhibit 5, Exhibit 6.
With respect to Exhibit 3, this is the ordinance that repealed the prior ordinances, which were in effect at the time. We believe that the current ordinances are unconstitutionally exclusionary, and the comparison between the two are part of Range's evidence. It shows, for example, in Exhibit 4 and 5, were these oil and gas zoning ordinances in place when the township granted conditional use permits for Range's existing well pads in Cecil Township. Ordinance 9-2011 establishes that oil and gas development as a conditional use, quote, in areas identified in an oil and gas overlay district within the township, which shall be established in a separate ordinance and includes relevant definitions. Ordinance 10-2011 establishes the overlay district. Exhibit 4, together with Ordinance 10-2011, is relevant to show standing because by comparison, it shows how the new ordinance, 9-2024, prohibits or restricts the use or development of land in which Range has an interest. And in that, under the prior regime, there were areas where Range could develop new pads and thus access now stranded leases. And similarly, to show that Ordinance 9-2024 operates as a de facto exclusion because it shows that setbacks are not necessarily exclusionary at lower thresholds. And insofar as the township's defense against a charge of exclusionary zoning is the existence of already permitted oil and gas well pads, Ordinance 9-2011, like Ordinance 10-2011, is necessary context.
We'll allow the exhibits.
Thank you. Range calls its first witness to the stand, Jeremy Matino.
Hey, before you begin testifying, could you please swear in the witnesses? Yeah, anybody who might testify today, can you?
Jeremy Matinko, Matinko. Which mic do you want me to speak into?
Are you ready to proceed?
Yes.
Please state your full name and spell your last name for the record, please.
Sure. Jeremy Matinko, Matinko.
Where are you employed?
Range Resources, Appalachia, LLC.
How long have you worked for Range, Mr. Batinko?
Over 15 years.
When you first started, what was your role with Range?
I was an ENS, or Environmental and Safety Technician, doing field inspections for Range Resources.
Have you always been in regulatory compliance roles while working for Range?
Yes.
Generally, how has your role evolved over time?
So generally, over time, I've taken on supervisory roles and expanded my environmental focus to other areas.
What's your current position with Range?
VP of Environmental Compliance,
And how long have you been in that role, sir?
a little over 1 year.
What are your responsibilities as VP of Environmental Compliance for Range?
So myself and my team work to ensure that all range employees, our operations, engineering groups, et cetera, are aware of environmental compliance regulations, obligations. I also manage that group, includes field employees that do inspections at sites, and also includes office employees.
Does your department have a particular role with contact with any Pennsylvania regulatory agencies?
Yes, so my group is the primary point of contact for the Pennsylvania DEP.
And does that role as being the primary point of contact with Pennsylvania's Department of Environmental Protection require a working knowledge of the regulations that Range must comply with for its oil and gas activities?
Yes.
Tell us a little bit about your educational background.
Sure. So I graduated from Ringgold High School in 2000 and Penn State University in 2004 from the College of Agricultural Sciences.
And what was your degree in, sir?
A Bachelor of Science in Agricultural Systems Management.
What is that?
That's a combination major that includes agricultural engineering, agricultural science, and agricultural business, several classes in natural resource management.
Do you have any certifications or other training related to your work at Range?
Yes.
And could you give us a couple of examples of those certifications and training?
Sure. I have a few certifications, but I'd say the main ones are CESWI, or Certified in Erosion, Sediment, and Stormwater Inspector, and Certified Professional in Erosion and Sediment Control, CPESC.
And how long have you been certified in each of those, with each of those organizations?
Or over 10 years for each of those.
How does someone obtain the certifications that you just identified?
So an applicant would provide their work experience and other credentials, apply to sit for an exam, and then take a competency exam on those topics.
Do you have to do anything to maintain these certifications after you've become certified?
Yes, there's a continuing experience and education requirement annually.
Did you do any other compliance work before you started working for Range?
Yes.
And where were you working before then?
So immediately before Range, I worked at the Pennsylvania DEP in the gas program as an environmental trainee and then a water quality specialist. And prior to that, I worked for the Washington County Conservation District as an erosion control technician.
You mentioned that you worked for the Pennsylvania DEP as an environmental trainee and water quality specialist, is that right? And what were you doing for DEP in those roles?
So inspecting oil and gas activities for compliance with environmental regulations.
And then what were you doing in your role with the Washington County Conservation District?
So I reviewed applications for earth moving activities within Washington County, and reviewed their erosion and sediment control plans, permits, and also inspected field activities at those sites.
So based on your experience, are you familiar with the regulatory environment in which oil and gas companies operate in Pennsylvania?
Yes.
Are you also familiar with the steps that companies need to take to develop natural gas wells and the environmental and the regulatory environment in which that takes place.
Yes.
Let's just turn to the development of natural gas wells in Pennsylvania. After obtaining site-specific oil and gas leases or rights, what are the first things that a company like Range needs in order to be able to drill a new well?
So at a basic level, an operator would need a well pad and a way to get to that well pad.
What is a well pad?
So a well pad is a flat work area that would be created using earth moving activities to stage the equipment that's needed to drill.
You know how Range sites its well pads?
Yes.
And can you tell the board what that process looks like at a high level?
Sure. At a high level, the geology department would determine what area they recommend for development activities. Land group would assess those sites, those areas, make sure that leases and the right permissions and everything are required. And also would have to refer to setback requirements that the state has in place.
So you mentioned setback requirements. What are some examples of the regulatory requirements that apply to where you can site a well pad?
So the Oil and Gas Act provides for the 500-foot distance from buildings and private water supplies and a 1,000-foot setback from public water extraction points, as well as other setbacks related to
How much space does Range need to develop a new pad?
So overall, Range would need around 15 acres to develop a well pad.
And does that space vary depending on topography?
Yes, absolutely.
Does that approximately 15 acres include an access road?
Yes.
How big is the well pad itself typically?
So Range typically targets a well pad that would be 315 feet by 480 feet, about 3.5 acres.
I was going to ask you that question. Why does Range need more than the 3.5 acre space for a new pad?
So the topography is one of the biggest factors. So obviously a flat pad would need grading. If we have an area that has steeper terrain, grading is necessary to create the flat surface. There are also several requirements that need to be met as far as erosion and sediment control and stormwater facility construction that are required by DEP.
Is there a minimum amount of space that Range needs for a well pad?
I haven't seen one permitted under 10 acres. Like I said, 15 is the average.
Are permits needed to construct a new well pad? Let's look at Exhibit 7. Sir, that should be, a copy should be in the binder that's in front of you. You have Exhibit 7 in front of you, sir.
Yes.
Are you familiar with Exhibit 7?
Yes.
What is it?
Authorization of coverage under the erosion and sediment control general permit for earth disturbance associated with oil and gas.
Is the erosion and sediment control general permit one of the permits needed to construct a new well pad?
Yes.
What agency issues the erosion and sediment control general permit?
Pennsylvania DEP.
I'm going to direct you to the middle of the first page of Exhibit 7, the paragraph that begins this authorization. Here.
Yes.
This paragraph refers to authorizing the applicant to conduct oil and gas activities using erosion and sediment control, best management practices, and post-construction stormwater management, stormwater control measures. What does that generally refer to?
So in general, that section just says that whatever entity holds this permit is expected and required to follow all of those applicable regulations.
So when Range obtains a permit, does it still need to conduct activities on the permitted site in accordance with the regulations and conditions identified in the permit?
Yes.
There are more than 24 numbered paragraphs in Exhibit 7, and we don't need to go through all of them, but could you give us some examples of what else is covered by this permit?
Sure, there are reporting requirements, notification requirements, record-keeping requirements, training requirements, and overall general operating requirements.
In your experience, how long does it take DEP to issue a decision on an environmental and sediment control general permit?
So typically, it takes at least 100 days for DEP to issue.
Why does it take 100 days?
So there's a very thorough review process where there's typically several rounds of back and forth between the applicant and the DEP.
Now, you mentioned access roads earlier in your testimony. Are there any other permits that Range may need for those roads?
Yeah, there could be. If it's connecting to a state road, there might be an HOP permit. Connecting to a local road, there might be a local municipality permit.
Does the erosion and sediment control general permit authorize Range to start drilling once the pad and access road have been constructed?
No.
Are there separate permits that cover gas wells?
Yes.
What agency issues the well permits?
Pennsylvania DEP.
Turn to Exhibit 8, please.
Yes.
You recognize Exhibit 8.
Yes.
What is it?
Permit application to drill and operate an unconventional well.
Turn to Exhibit 9, please.
Got it.
Recognize Exhibit 9.
Yes.
What is it?
Instructions for completing an application for a permit to drill or alter an oil and gas well.
Are the documents marked as Exhibits 8 and 9 available on DEP's website?
Yes.
Can you walk us through some examples of the information that Range would need to provide in an application like Exhibit 8?
Sure. So basic information, location of the proposed well, details of the proposed well, like the length, depth, target formation, distance to any water purveyors, a lot of questions regarding proximity to landfills, gas storage fields.
Do you know whether the Department of Environmental Protection has specific standards for whether to grant or deny a well permit like Exhibit 8?
Yes, they do. They have regulations that give them the criteria to approve or deny.
Are there any other permits that Range needs to obtain before it can begin drilling from a well pad?
There could be on a case-by-case basis, but the two that we covered apply to every new well.
Once Range has drilled its wells, is that the last time Range has to deal with regulations and regulators related to a specific well site?
No, not at all.
We don't need to go into all of them, but what are some examples of other regulatory requirements that Range needs to comply with even after it's drilled its well?
So there are a number of reporting requirements due at all phases of the process, after drilling, after completion, during production, waste reporting requirements, waste handling requirements, labeling requirements, inspection requirements, monitoring requirements. That's just to name a few.
We've talked about a few of the applicable regulations that focus on well and well pad siting. Are there any other non-DEP regulations that Range needs to comply with for its oil and gas development activity?
Yes, there are also federal regulations.
So what we've talked about today is just a few of the applicable regulations that focus on well and well pad siting and construction.
That's correct.
Tinko, are you familiar with Range's existing well pads in Cecil Township?
Yes.
And what are those well pads?
The Ingle, the Troyer, the Augustine, Schultz, and the Connor Samuel.
Connor Samuel well pad built?
Yes, the Connor Samuel pad's built.
Has drilling commenced at the Connor Samuel?
Yes.
Has Range obtained all the permits that it needs to drill wells at the Connor Samuel well Once the permitted Connor Samuel wells have been drilled, will Range be able to start producing natural gas from those wells?
No, drilling is only the first part of the process. There are other phases that would need to occur, plus the installation of permanent production equipment, plus placement of gathering system or facility gas from the pad.
Now, can you describe what the gathering systems or facilities are that you just mentioned, how they work?
Sure. So what I was referring to would be gathering system that would typically be a pipeline and associated compressors and other motorized equipment potentially that would leave the well site and go to a sales or process point.
Can Range continually produce and sell natural gas from the Connor Samuel without that gathering equipment?
No.
Does Range ordinarily have a contractor engaged to install gathering equipment at its wells around the time that it plans to drill them?
Sorry, can you repeat?
Sure. Does Range ordinarily have a contractor engaged to install gathering equipment at its wells around the time that it plans to?
Yes.
Assuming that Range's contractor was able to install the gathering system, do you know when Range planned to begin producing natural gas from the Connor Samuel wells?
That's my understanding that the Connor Samuel wells would be ready to produce gas later in 2020.
What will happen to the natural gas from the Connor Samuel gas wells if the gathering equipment cannot be installed?
That would be stranded.
I'd like to offer into evidence Exhibits 7, 8, and 9 into the record.
Any objections?
Other than the relevance of them.
Okay. 7, 8, and 9 are admitted.
You turn back to Exhibits 4 and 5.
Yes.
These were previously admitted. Exhibit 4 is 9-2011, and Exhibit 5 is 20-2011. Were these ordinances marked as Exhibit 4 and 5 in effect when Range applied for and received its permit for Connor Samuel?
That's my understanding, yes.
I have no further questions for this witness.
All right, we will start with the township for any cross-examination.
Thank you, Mr. Volz. Good evening, Mr. Matinka.
Hello.
So, we looked at Exhibits 7 and 8, which were blank applications, right?
Right.
Okay. And you presented blank applications because you actually don't have an application with the DEP currently for a new well pad in Cecil Township. Is that accurate?
Yes.
Okay, that's a correct statement.
My knowledge, Range does not have any applications. Thanks.
Mr. Matinka, you would agree with me that Ordinance 9 of 2024, which your council entered into evidence, allows for unconventional oil and gas well pad development anywhere in the township, subject to setbacks and upon approval of a conditional use application, right?
Objection. It's beyond the scope of his direct examination testimony. Witness does not profess to be an expert on the ordinance.
Can you repeat the question then?
Ordinance number 9 of 2024, which your council entered into evidence, allows for unconventional oil and gas well pad development anywhere in the township, subject to setbacks, and upon approval of a conditional use application, right?
Objection. It also calls for a legal conclusion.
To the extent you know the answer, you can answer.
Yeah, I really don't know that answer.
Let me ask you this,
Okay.
Mr. Mattinson.
Sure.
At any time before November 4th of 2024 and today, has Range Resources filed a conditional use application for a well pad in this township?
Not to my knowledge.
At any time between November 4 of 2024 and today, has Range filed a conditional use application for any oil and gas facility in the township?
And that's a little bit out of my purview, but not to my knowledge.
Okay, thank you.
Sure.
So let me set up some exhibits here, if you don't mind. I have a demonstrative and I have some exhibits for the board. Well, you know what? I'm going to hand you the exhibit too, so we'll just use this as a. Let me hand out some exhibit findings. Okay, Mr. Matinko, you answered a couple questions about some existing well pads in the township, right?
You mean for Ms. Brown?
Yes.
Yes.
Okay. So let's go through in a little more detail the existing well pads that Range has currently in the township, okay?
Okay.
All right, let's start with the Schultz Bernard, number 11289. And if you turn in your exhibit binder to exhibit number 2, I will represent that that's the same map that we see here on the easel. Are you there?
Yes.
Okay. So do you see the Schultz Bernard well pad on the map there?
Yes, I see that label.
Okay. Yep. And that is a Range Resources well pad, right?
Yes, the Schultz is a range pad. Yes.
Okay. And there are 8 total wellheads on that pad. Is that correct?
I don't remember offhand.
You don't know how many wellheads are on that well pad?
Not offhand, no.
Do you know how many are drilled? Do you know how many wellheads are drilled on that well pad?
Not offhand, no.
Okay. If I told you there were 8 wellheads on that well pad, would that surprise you?
No.
Okay. And that 7 of them are drilled. Does that sound about right?
Again, I don't remember offhand.
Do you remember the spud dates approximately on that well pad? Just the year.
They're 2023 or 2024. It's more recent.
Okay.
If that's good enough for your question.
Okay. And can you just, for the record, let the board know what a spud date is?
The spud is when the wells are initially
So the Schultz Bernard well pad is one of the newer pads in the township, drilled approximately 2023. Is that fair?
Yeah, I don't remember if it's 2023 or 2024. If you have something there you're looking at, I'd be glad to look at it.
Okay, that's good enough.
Okay.
In the very recent history, it's been drilled, right? 2023 or 2024.
Objection. This is being repetitive, and I'd ask that we not ask repetitive questions.
Let's move on to the Augustine George well pad. Do you see that pad on the map?
Yes.
Okay. And I think you've testified that is a Range Resources well pad, right?
Right.
And do you know how many well heads are on that pad?
Not offhand, no.
Okay. Would it surprise you if I said there were 16?
I don't remember how many are on the Augustine pad specifically.
Mr. Volz, may I ask that some order be requested from the members of the audience? I'm hearing lots of commentary. It seems to be destructive, and I don't think it's appropriate for this proceeding.
I have heard some comments. I don't know if I'd categorize them as disruptive yet, but for members of the audience, for our stenographer's benefit and everybody else, everybody will at the end of the hearing be given an opportunity to talk and comment. But please, so we can hear the witness, refrain and keep your comments to yourself so he can testify and the attorneys can hear what they're saying and come up with their next questions. Thank you.
Mr. Matinka, your role is in regulatory compliance, right?
Right.
And it's your job to be familiar with the well pads in Cecil Township. Is that fair?
Yes.
Okay. So going back to the Augustine George well pad, would it surprise you that there are 16 wellheads on that well pad?
Again, I think for the second or third time, I don't remember exactly how many wellheads are on that pad at this point.
And how about, do you know how many are drilled on that well pad approximately?
Isn't that the same question?
No, I was asking first how many wellheads are there, like potentially, and how many have actually been drilled.
I guess I would have the same answer because you're asking a little oddly. It wouldn't be a wellhead if a well wasn't drilled. So that doesn't make much sense to me. But I don't have the same answer. I don't remember exactly how many wells are on that pad.
Okay, so to be clear, what I'm asking is how many potential wellheads could be on a particular well pad? And I'm going to go through everyone in the township because I think it's important for the record to understand how many pads you have in the township, how many wellheads potentially, and how many you've drilled. So the first part of my question was, would it surprise you to know that there are 16 potential wellheads on the Augustine George well pad?
So the first time you asked me, I don't believe you said potential. So that formed my answer. So now that you're saying potential, yes, it would make sense. I feel like 16 is the number that I heard were permitted.
Thank you. Thank you. That's what I was looking for my first question. And then my second question is, are you familiar with how many are currently drilled at the Augustine George well pad?
Again, same answer. I'm not certain how many have been drilled at this point on the Augustine pad.
Would it surprise you if I told you that 9 wellheads have been drilled?
I don't think it would surprise me, but that doesn't confirm my answer one way or the other.
Are you generally aware of the spud dates on the Augustine George well pad?
So my recollection is there were 2 visits to that pad, one within the last couple years and one prior to that.
Okay, thank you. Now, let's move on to the Connor Samuel well pad. And you answered a couple questions about this on your direct. Do you see that on the map?
Yes, I see the label for Connor Samuel.
Obviously, that's a Range Resources well pad, right?
That is a range pad, yes.
Yep. And how many potential wellheads are available at the Connor Samuel well pad?
I don't know specifically how many wellheads are proposed on Connor Samuel pad.
Okay, so you just answered some questions about him. You prepared this evening to answer questions about Connor Samuel, but you don't know how many wellheads are on that pad.
Well, again, there aren't any wellheads on the pad right now. Range just started drilling that pad.
Okay. Again, the first part of the question is how many potential?
I'm not sure how many potential wells on the Connor Samuel pad.
And you just said that you're starting to drill on Connor Samuel, correct?
Correct.
How many wellheads are currently being drilled?
I believe for this round, Range is pursuing 5 wells.
Now, you testified, you answered some questions about gathering equipment, and that typically you contract to get gathering equipment around the same time as you establish and apply for the well pad. Was that right?
Can you ask that again?
I believe you testified, but correct me if I'm wrong, that you typically contract with entities related to gathering equipment and related to the well pad around the same time as you're establishing the well pad.
Right, that's my general understanding. It's outside of my responsibilities.
Okay, so as you're currently drilling at Connor Samuel, right?
Right.
Okay. Are you trying to say that Range Resources didn't establish a contract for the gathering of the gas at Connor Samuel? Is that what you were trying to say?
I don't remember trying to say that, no.
Okay, so you're currently drilling, and you believe Range Resources has contracted for the gathering of that gas, correct?
I don't remember saying that specifically.
Okay, well, tell me, please. You mentioned being potentially stranded, so I'd like to understand how Range Resources is stranded at the Connor Samuel well pad.
I believe I answered a hypothetical question that said if Range were unable to, Range's contractor was unable to install those gathering lines, then the gas would be stranded. I don't think I made any allusion that we actually were or were not.
Okay, so as you sit here today, Range Resources is not stranded at the Connor Samuel well pad.
Objection. Calls for a legal conclusion and an interpretation of the ordinance.
Overruled. He used the phrase stranded, so he can use it how he means it, or he understands that term.
Sure. Restate the question then.
You alluded to answering a hypothetical question, and I'm asking you the actual question. As you sit here today, Range Resources is not stranded at the Connor Samuel well pad. Is that accurate?
Same objection.
Overruled.
I guess I would testify that it's not accurate to say that it's stranded right now because it's also not capable of producing gas at this point.
Okay. At what point do you contract with an entity for production and gathering of the gas?
So again, outside of my realm of responsibility, but in general, as the operator's working through development of the other wells, of the wells on that site.
Okay, so would it have happened already? Is that something that would happen by the time you start drilling at a well pad?
I think it's safe to say it would be in process or in progress. I think every case is going to be different.
And is it in process at Connor Samuel?
That's outside of my area of responsibility, so I don't know.
Who would know?
It would probably be a combination of teams.
Which teams? Who are those people who know that answer?
Sure. So folks that work with or contract gathering companies.
Is there a particular group at Range Resources who does that?
Say again?
Is there a particular group at Range Resources who does that?
Yes.
What is the name of that group?
I believe that would be I don't know the specific name, and I could tell you're looking for a really specific name, so I don't have that.
You generally know what the name is?
Yeah, I would say a midstream coordination group, but
Okay. Okay, so as you are just starting to drill at Connor Samuel, then is it fair to say the spud date is now, 2025?
yes.
Now, all the pads that I've mentioned so far, they were all approved through the township's conditional use approval process. Is that right?
That's my understanding, yeah.
Okay. Now, let's move on to some other range well pads in the township. You mentioned the Engel well pad. Do you see the Engel well pad on the map?
Yes, I see that label.
That's another range resources well pad, correct?
Yes.
And a potential of 7 total wellheads on that pad. Does that sound right?
Again, I don't remember the specific number of wells that are on that pad, but that sounds right.
Are you familiar with how many are drilled on that well pad?
Again, same answer. I don't remember specifically how many wells are on that pad.
Would it surprise you if I said 6 have been drilled? Does that sound right?
I know the numbers around there, but I don't know specifically how many wells are in production on that pad.
Now, this Engel well pad is also another well pad that was approved through the township's conditional use process. Is that right?
That I don't know.
Is this an older well pad?
Yes.
Do you recall generally the spud dates of this well pad?
Maybe the 2011, 2013 timeframe. Again, information that's pretty easily accessible through DEP's records, but if you have something you're looking at, it might make this easier.
Okay, you're just not familiar though off the top of your head.
Correct.
Okay. The Troyer Space Management Unit 10H, that's a range well pad, correct?
Troyer Space Management Unit 10H would be a well.
It's a well, not a well pad.
Correct.
So if you take a look on the map, do you see the Troyer Space Management Unit on the map?
Yes.
Okay. As it appears on the map, is that a pad we're looking at, or is that one well?
The way you have it labeled on that map, it says Troyer Space Management Unit 10H, so that would refer to an individual well.
Are you familiar if there are other wellheads on that pad?
Yes, there are more than one well on the Troyer Space well pad.
Are you familiar with how many wells are on the Troyer Space well pad?
Not specifically, no.
Would it surprise you if I told you there were 7 wellheads on that well pad?
Sounds about right, but again, I don't know 100%.
And all of the wellheads on that pad are drilled. Is that right?
If the wellheads exist on the pad, then they're drilled.
Yeah, okay. Okay, so that particular site is drilled out.
That's not what you
Action
just
vague.
asked.
Is there any potential additional drilling that can take place on the Troyer well pad?
Really not something that's within my realm. I mean, you could drill additional wells on any well pad. You're asking me, from what I can understand, am I aware of any planned wells on that pad? And I'm not.
Okay. That particular well pad, and I know you referred to the specific unit 10H as a well, but let's talk about the Troyer well pad. That particular well pad was approved through the township's conditional use approval, correct?
Again, being an older pad, I'm not certain.
How old is that pad?
That pad was probably drilled in the 2011 to 12 or 13 timeframe.
Now, there's a couple other well pads on this map here. There's the Cowden well pad, right? Do you see that?
Yes, I see the label that says Permitted Cowden Wells, Atlas Resources.
Range is not the operator on that pad, correct?
Correct.
And the Rising well, do you see that on the map?
I see the label Permitted Rising Well.
And Range is not the operator on that pad, is that right?
Right.
You know who is?
based on this map, it says Special JHR Corporation.
Then we have the Fell Unit well. Do you see that on the map?
Yes, I see that label.
Now Range is the operator on this well. Is that correct?
That's what your sheet has, but I'm not familiar with that well.
Okay. So you're not aware of whether the Fell Unit is whether Range is the operator on that well pad or somebody else?
I'm not familiar with the Fell Unit well at all.
Okay. So, and let's just count them up. The wells that you are familiar with, that Range Resources is the operator of the well pads, are the 5 that you've just testified to.
Yes, Range is the operator of the Schultz, the Augustine, Connor Samuel, the Engel, and the Troyer.
Thank you. Okay, so now when you place an unconventional well pad in the township, you aren't just pulling oil and gas from directly underneath the drill site, correct?
Objection goes beyond the scope of direct.
Mr. Volz, this is a zoning hearing.
I'm
he is
going
he-
to overrule the objection to the extent you know the answer. Please answer the questions.
Can you state it again? I'm sorry.
When you site an unconventional well pad and you drill, you're not just pulling the oil and gas from directly under the drill site, right?
Right.
That'd be conventional drilling, right?
That's kind of a broad assessment to just say that's conventional drilling, but
Generally.
maybe ask a different way. I don't want to have to get technical.
So I'm asking we're going to get into the difference between conventional drilling and unconventional drilling at a very broad level. So conventional drilling, you're generally pulling the oil and gas from under the drill site, correct?
And I think I might have a difference in understanding from what you're getting at here, so maybe ask again.
Why don't you define conventional drilling for me?
So that would generally be shallower drilling. Unconventional would be drilling to a certain depth. Maybe you don't realize you can have an unconventional well that is vertical.
Typically, in an unconventional well pad, you drill down, as you mentioned, vertically, and then you drill out horizontally. Is that fair?
Yes.
Okay. And as a driller, that horizontal reach that Range has is quite extensive, isn't it?
It depends on how you define extensive, but it can be lengthy, yes.
How many miles can you reach out horizontally in an unconventional well?
I don't know what the maximum potential is. I think that's yet to be found, but we've gone up to 20,000 feet.
You've extended out horizontally 20,000 feet.
Yes.
Okay. So 4 miles?
Roughly, yes.
Okay, great. And as technology advances, you could go further, couldn't you? You could extend further horizontally.
Potentially.
Now, you drill, you meaning Range and other operators, you drill in drill lanes, right?
In what?
Drill lanes.
Not familiar with that term.
Okay. Well, answer this for me, please. You don't go down vertically and then out horizontally and have a bunch of drill lines crisscrossing each other, right?
Generally, no, wells don't crisscross each other. They're more parallel.
Okay. So you want lanes to run parallel, correct?
From a general point of view, yes.
Are you familiar with horizontal lines that actually cross each other?
What do you mean?
So you just said generally they run parallel. So my question is, are you familiar with times when you actually have horizontal lines that are crisscrossing or running perpendicular to each other?
Well, I think you're not taking into account that there could be different depths at which wells are drilled. So I don't think I'd be comfortable saying that wells are perfectly parallel.
In any given depth, if you're on a similar, within a similar depth, you generally want your drill lanes to run parallel, correct?
Again, from a general perspective, yes, but I'm not a geologist.
Okay. And I'm just asking these at a very general level, so we're all talking about the same thing here, because I'm going to ask some more questions about, what this looks like and how it plays out. So generally, at any given depth, you have drill lanes, or whatever you want to call them. What do you like to call them, if you don't call them drill lanes?
In the horizontal wellbore, the lateral?
Your laterals. Okay. Generally, you like to have your laterals running parallel at any given depth, right?
Generally.
And is there a particular path that it goes? Like, is it northwest to southeast, or is there a particular way you like those horizontal bores to run?
Again, I'm not a geologist, so I don't really know what they truly prefer or if it's based on leases. There could be a number of factors that.
And when you're preparing to drill, you actually create units. Is that right? Call them drilling units?
Yes.
Okay. And how many contiguous acres are needed to make a unit?
I don't know that off the top of my head.
640 contiguous acres? Does that sound right?
Again, I don't know all the rules and laws of unitization and things like that.
That's not part of your roles and responsibilities at Range to be familiar with that?
Right.
Are you aware of when you're creating a unit, you need to sign up the various landowners, correct? You understand that part?
Yes.
Okay. And you can't actually force people into a lease. Is that your understanding?
Yes, that's my understanding.
Okay. So you need to create a unit, a contiguous unit. You're not sure how big it needs to be, but you need to create a contiguous unit, and you need to sign up all those landowners, right, to lease their oil and gas rights to you, to Range, right?
Right, Range would need to lease owners.
I'm sorry, I didn't catch that.
Range would need to lease the ground rights where we're going to develop, yes.
Now, let's go through very quickly the sequencing of events. You did testify to this, but I want to make sure I have it right. So I'm interested in particular about the timing sequence of when things happen. So I think I heard you say first you obtain the lease rights. Is that the first step when you're thinking about establishing a new well pad?
I'm just thinking back to the questions I was asked earlier. I think I actually said that first our geology team would make a recommendation on where we'd like to develop, and then the land team would secure surface leases. You know, we mainly talked about siting of a well site, not really leasing.
You do some geological exploration first. Yes?
I'd say review, yes. Exploration could mean other things, so.
What was the word you used?
Pardon?
What was the word you preferred? Geological what?
Review.
Review, okay. So you do a geological review first, right?
Right.
Then you secure leases with the property owners, right?
Well, again, I think I was asked specifically about siting, like surface type use. And so, yeah, once geology would identify an area that we wanted to develop, then our land group would pursue the rights and authorization to use those lands.
Okay. And then next, do you work on the creation of the unit?
Again, outside of my realm of responsibility, so I don't know that answer.
So you're not the person to talk about units and unitization, right?
Right.
Who would that be?
That would be our land department.
At some point, you're creating a unit. You're just not sure when.
Correct.
Okay. And then at some point after that, is that when you start to get your permitting from the DEP?
What are you asking specifically? At what point?
Correct. So let me just back up. Again, my question is about timing and sequencing.
Mhm.
So I'd like to know what happens first, what happens second, what happens third. So if we start with you're desiring to put a well pad
Okay.
somewhere in Cecil Township. Step one, geological review, right?
Yes.
Step two, securing leases with property owners, correct?
Again, I think I was asked about surface use, and you're wanting me to commit to certain leasing questions that I just don't really know.
Okay, I'm currently not asking you any details about the leasing. I'm asking about the sequencing of events when Range Resources decides it wants to site a well in Cecil Township, for example. What happens first, what happens second, what happens third? So geological review for sure, right? First.
Okay.
Is that right?
Okay.
Yes?
Is that what you're saying?
I'm asking you. I'm not
I've
testifying.
already answered it multiple
Okay,
times.
I'm just trying to get the sequence down, and somehow it's been difficult. So after geological review, you're securing the leases.
At some point, yes.
Okay, and at some point, and I know you don't know this, but you're creating a unit at some point.
Yes.
Okay. And then are we getting permitting from the DEP?
Obviously, we're pursuing permits through the DEP prior to drilling the wells.
And in terms of sequencing, it happens sometimes after geological review and after you start securing leases, then you go over here to the DEP and you apply for your ESCGP permit and then you apply for your drilling permit.
Right, prior to building the well site, we would apply for the ESCGP. Prior to drilling the wells, we would apply for the well permits.
And then at some point, you have to come to the township. And in Cecil Township, you'd apply for a conditional use approval, right?
That's my understanding, yes.
Okay, and does that happen after you start the process with the DEP?
I'm not sure.
You're not sure of the sequencing? Is that your answer?
Right.
Okay. But there is DEP application, and then there's application to the township. You're not sure which comes first, or if they're happening simultaneously.
Correct.
Who better can answer questions about sequencing?
There are a regulatory group or local government group or a legal group.
And I'm sorry, did you say earlier you were in the regulatory group?
Environmental compliance,
Environmental compliance, okay, so different group.
yes.
Okay. Has Range, to the best of your knowledge, performed any geological studies to site a new well in Cecil Township?
I don't know.
And again, who knows the answer to that question?
For geology department.
And I know you didn't know a lot about units and unitization. Are you familiar with what units exist in Cecil Township? And let me just preface it by saying this. is like when there's the Connor Samuel well pad, is there a Connor Samuel unit that is associated with that well pad, or are the units titled differently than the well pads they're connected to?
To the best of my knowledge, the units are associated with the individual wells.
And the naming conventions are the same as the well pad name, is that fair?
As far as I know, yes.
Okay, so just to be clear, like we have a Connor Samuel unit in Cecil Township, right?
Again, I think my understanding that the units are related to the wells and not the pad, as you're suggesting.
I'm not sure I appreciate that distinction. Is there a Connor Samuel unit in Cecil Township?
Yes.
Okay. And it's connected to the Connor Samuel wells?
I think the way you're characterizing it is a little bit different, I guess, than I would understand it, because I said that the units are associated with the wells, and you're suggesting that the unit is associated with the well pad. There's a difference.
So is the Connor Samuel unit associated with the wells on the Connor Samuel well pad?
If you're referring to all the Connor Samuel units as the Connor Samuel unit, I guess you could say it that way, but that's just doesn't seem right to me.
Okay. How would you say it?
That there would be a different unit for each of the pads each of the wells, that are being drilled from the Connor Samuel well pad.
Would each of those units be called Connor Samuel?
In part, yes.
Okay. And then would they have subparts?
Right.
Okay. So in this example then, let's sticking with Connor Samuel. Can you tell me the names of the Connor Samuel units then? Like, is it subpart A, subpart B? Like, what are the unit names?
To my understanding, they're associated with the wells themselves, the well numbers.
The well number?
Right.
Okay. And I don't know the well numbers on that pad, but if there were a well number 27 on Connor Samuel, then there would be a Connor Samuel unit number 27 associated with Connor Samuel well number 27.
That's what I'm suggesting is my understanding.
Okay. Are you aware of whether Range has established or is working on any new units in Cecil Township?
I don't know that answer.
Because you're not the right person, is that why?
Right.
Okay. Are you aware of whether Range Resources has secured leases with property owners that would be associated with a proposed new well pad in Cecil Township?
I'm not aware of that.
Now, is that something that within your knowledge base? So if it was happening, would you be aware, or do I not have the right person?
You don't have the right person.
Who is the right person to answer those questions?
Question of if we are pursuing leases, is that your question?
Correct.
Or land department?
And I think we started with, but to be clear, Range Resources has not applied for any new permitting from the DEP for a new well pad in Cecil Township, right?
Not to my knowledge.
Now, with the type of horizontal reach that we were talking about earlier, Range can actually access oil and gas that is located underneath Cecil Township from surface well pads outside of Cecil Township, right?
Objection. It's irrelevant.
This speaks directly to their standing, which on direct, I haven't even heard anything that speaks to their standing. I'm trying to elicit it on cross-examination, and this obviously is relevant because we're talking about an allegedly exclusionary zoning ordinance related to folks' oil and gas rights. So I'm going through all the different ways folks can access their oil and gas rights, the ways they already have, and whether they can access those rights from outside the township.
Objection's overruled. You can answer the question.
Can you ask it again?
Yes. So with the type of horizontal reach that you testified to earlier, Range Resources can actually access oil and gas that is located underneath of Cecil Township from a surface well pad that exists outside of Cecil Township. That's possible, right?
Say technologically that's possible, yes, but if there are not leased portions, then that would be preventative. So there are a number of factors that would determine that answer. So I really can't say yes or no.
Sure. Well, you're always going to need to obtain your leases, right? You have to enter into leases with the property owners, right?
Right.
Okay, so let's assume you've entered into leases with the property owners in Cecil Township. Could you cite a well pad right outside of Cecil Township and you could still access their oil and gas rights from a surface well pad that exists outside of Cecil Township? You can do that, can't you?
Same objection. And I'd like to note for the record, the issue of whether or not oil and gas rights can be accessed from outside the township is totally irrelevant under the case law to a challenge for exclusionary zoning.
So noted. Objection overruled. You can answer the question.
So I guess my response would be similar to what I just said, but theoretically, you'd be able to drill horizontally from outside of the township. But it would be contingent upon a lot of other factors.
Sure. So assuming those factors are in place, you have your leases, you have your unit, you got your DEP permitting, you could site a well pad outside of Cecil Township, and you could horizontally drill underneath Cecil Township and access oil and gas rights of residents within Cecil Township, correct?
Objection. Lacks foundation.
Overruled. You can, but we are getting a little bit repetitive. So
I'm just trying to get the answer. I haven't gotten a straight answer.
I object to that characterization. The witness has been very patiently answering many questions and many times the same question.
sir, if you could answer the question. Thank you.
Hypothetically, given a number of factors are met, well could be drilled horizontally from outside of any municipality into another municipality.
Thank you. Because unconventional drilling, it doesn't have to follow these surface level borders of municipalities, right?
Right.
Okay. And to be clear, in that scenario where you're outside of Cecil Township on the surface and you're drilling underneath Cecil Township, you don't need to come to Cecil Township to get approval to drill underneath it, correct? From the township.
My knowledge, you wouldn't need approval, but you would have to make notice.
Okay, thank you. No approval from the township.
I don't believe so.
Okay, thank you. Okay. You turn to Exhibit 3, please.
Have it up.
So Exhibit 3 is a map that was created by Gateway Engineers, which is the township's engineer. And you see on this map that the Schultz-Bernard, the Connor-Samuel, the Augustine, the Engel, and the Troyer pads exist on the map. You see them?
To raise an objection, this map has not been properly placed into evidence. Therefore, questions regarding this exhibit are improper.
I'm happy to place this map into evidence when it's actually the township's case and we put our engineer on the stand. At this point, I'd like to ask this particular witness some questions about the map.
I mean, yeah, I mean, to the extent he can opine on a map he, I presume, is not familiar with, I will allow you to proceed and ask him questions, but we'll see where it develops.
Okay, thank you. Do you know how large in area Cecil Township is?
Not offhand, no.
Okay. If you look at the top of this map, there's a square box.
Yes.
And it says there, it is estimated that approximately 10,360 acres of Cecil Township is accessible from the existing pad locations. This makes up approximately 61.38% of Cecil Township's 16,879 acres. Do you see that?
I see that box, yes.
Okay. And again, I appreciate that you wouldn't independently know how large in terms of acreage Cecil Township is. But we can ask our engineer about the fact that it's 16,879 acres.
Okay.
So I'm not going to ask you to answer that question. Okay. Do you see this area shaded in purple?
Yes, I see the shaded area.
Okay. So if we look at, there's a box in the bottom left of the map, and it has assumptions on it. Do you see that box?
I see the box labeled assumptions, yes.
Okay. Now, the first assumption is drilling lane offsets of 750 feet. Is that meaningful to you at all?
Meaningful in what way?
Do you understand what that means?
I'm going to object. This witness has never seen this document before, and questioning this witness regarding the meaning of a document he's never seen before is totally irrelevant.
I believe the question is whether the assumption that drilling lanes are offset by 750 feet is the question, regardless of what this map shows. Is that correct?
That is correct. I'm asking him if I'm going to go through each one, and I appreciate he hasn't seen the map before, which is why I'm going to go through question by question what is on this map. And the first question is whether that's a reasonable assumption that drilling lanes are offset by 750 feet. That seem about right to you?
Again, that's the assumption whoever made the map, which doesn't appear to be a range map. So I'm not sure what that assumption is really based on, so I wouldn't be comfortable answering that.
What would be a reasonable assumption, in your opinion, of drilling lane offsets?
Well, being as I'm not a geologist or a drilling engineer, that's a little bit outside of my purview, so I don't really have a number or a range that I would even be willing to give.
You're unable to answer that question.
Right.
Okay. How about the next assumption? 16 wells per pad maximum. Is that a reasonable assumption?
Same objection.
Noted. Overruled.
Again, not a range assumption, so I'm not really sure what drove that assumption. So I wouldn't be comfortable saying that is right or wrong.
Are 16 wells per pad, is that the maximum amount of wells that you can put on one well pad?
No?
Okay. Is that the typical amount of wells that Range puts on a well pad?
Not to my knowledge.
Okay. So the number 16 wells on a well pad is meaningless to you? Is that what you're saying?
Each well pad is different, so to generalize it and say that that applies to every pad is really not accurate.
How about the maximum drilling lane length of approximately 3 miles? I think you already testified that you actually have extended up to 4 miles, right?
Approximately.
Okay. So is that a reasonable assumption in your opinion?
Again, that's well and well site specific. I've seen shorter and I've seen longer.
Thank you. So looking at this area in the purple, right, using those assumptions, the purple demonstrates the existing coverage of subsurface oil and gas rights in Cecil Township connected to the 5 range well pads.
Objection.
I am going to
Recommendation.
sustain that one. He's answered the questions about, the assumptions as a factual matter, but I don't know how he can agree with or testify as to the conclusions based on this map. So I'm going to sustain that objection.
Let me ask you this. The area on the left side of the map, the area shaded in purple, in your opinion, is there another place in that area shaded in purple where Range could site another well pad?
I'm not sure what you're asking for my opinion on.
Yeah, I guess I'm asking, I'm assuming you don't put well pads on top of well pads that are in close proximity, right? Because you have a large horizontal reach, as you've explained, right?
I think making a general statement like you're trying to get me to isn't really accurate because you can see the distances on this map that's been generated. So I don't know what you want to ask me. Go ahead.
Okay, well, I did ask, and I'm just, and you may not be the right person to answer this, but as it relates to the area shaded in purple, and based on your knowledge and understanding of the work that you do and the work Range does, is there an area or need to put another well pad in that area in the purple?
Objection.
Any need that you,
I'm sorry. Finish your question.
is there any need that you can see to put another well pad in this purple shaded area?
Objection. There's been no foundation laid that this map represents anything. And so the question is unfair to the witness, and it's asking for an opinion based on a document that has not been entered into evidence or otherwise identified or authenticated.
I think we have had maps introduced into evidence, though, and I think the question isn't dependent on accepting the assumptions. I think it's just, in his opinion, to the extent he knows, would Range look to put a well pad anywhere in the purple area in the map, to the extent he knows?
I think just generally, that purple area assumes 100% leased acreage. I highly doubt that's the case. So I really can't answer that question.
Okay, I'll move on to a different part of the map. We'll have other testimony about the map. Let's look at the right side of the map, okay? The area not shaded in purple. Do you see that area?
Yes.
Now, under the zoning ordinance that Range is challenging, ordinance number 9 of 2024, is there any place in that non-shaded area where Range Resources can site a well pad?
Same objection. The witness is being asked to testify about a document that's not been authenticated, established as something other than hearsay, and the assumptions are lacking foundation at this point in time.
Mr. Volz, this goes to the very reason of why we are here today. They're claiming that this ordinance is exclusionary, and I'm entitled to ask him some questions as to whether he has even, and Range has explored the siting of well pads to determine if it is indeed exclusionary or not exclusionary. And that's the next series of questions that I'd like to ask this witness.
And I believe your question, could you just re-ask your
Yes,
question?
so I had asked, in the non-shaded area, are you aware of whether Range Resources can put a well pad anywhere in that non-shaded area? Under ordinance number 9, 2024. Are you aware? That's the question, yes or no?
say that my general understanding of the new ordinance, which is not in depth, but is that it prohibits range from siting any well pads in the township, any new well pads.
Okay. These are exactly the questions I'd like to get to, so thank you for that. Have you or anyone at Range actually crunched the numbers to determine whether you can site a well pad anywhere in the township under the new ordinance?
I have not personally done that. That's not within my area of responsibility.
Okay, are you aware of whether anyone at Range Resources has undergone that exercise?
I believe they have.
Okay. Who's done that? Who did that?
I believe that would have been done through our GIS department.
Who's in the GIS department? Like, who would lead that up?
I believe that's under the geology group.
Is there someone in particular?
I believe that's part of what we're going to present tonight.
Oh, so do you have a witness here tonight who is going to talk about setbacks and whether Range has explored whether it could site a well pad in the township?
That's my understanding. That's not part of my presentation.
Okay. Who is that? Who is here tonight who's going to answer those questions?
His name is Mark Limbrunner.
Okay, so I'm going to save some of these questions for Mark Lindbrunner.
Okay,
Okay, because you're not the person.
correct.
Okay. Do you have with you tonight a copy of any of your leases with landowners here in Cecil Township?
I don't personally know.
Are you familiar with your Range leases with landowners?
That's not part of my area of responsibility.
Who's most familiar with the actual leases between Range Resources or whoever the entity is and landowners in Cecil Township?
Our land department.
Is anyone here tonight going to testify about the actual leases?
Mr. Volz, I believe that this is not appropriate questioning. It's got nothing to do with the witness's testimony. It's got nothing to do with Range's exclusionary challenge.
I mean, I think it does go to their question of standing, but I get your point. You didn't ask him anything about leases or anything like that on direct. So, you know, to the extent he hasn't brought this up, you know, I don't think there's a need to cross-examine on questions that he hasn't addressed. So,
Sure, we can wait to ask the appropriate
Right,
person.
so
if
I
there
would-
is going to be someone here tonight
and if
who's going to
there's
talk about
not,
leases.
you know, it's their burden of proof for standing and rightness. So,
Okay, so you're not the person for leases. Let me ask you this, and you may or may not be the person to answer these questions. You're familiar with local legislators, you know, passing or amending zoning ordinances. Are you generally familiar with the process?
Very generally.
Okay. Would you agree with me that township supervisors are the ones charged with protecting the health, safety, and welfare in their municipality?
Objection. Goes beyond
sustained.
the
I don't
scope.
think he needs to testify as to the capabilities of the supervisors.
Would you agree with me that the township supervisors, as it relates to zoning, are allowed to determine where activities take place?
Same objection. well
Yeah,
beyond the scope of this
sustained.
testimony.
Would you agree with me that there are inherent risks associated with unconventional drilling?
Say they're generally risk associated, yes.
Okay. Risks to property, right?
Potentially.
Risks of personal injury,
Potentially.
including loss of life.
Potentially.
And the closer an occupied structure is to a well pad, the greater the risk, right?
That could be your opinion.
I'm asking you to answer that question.
What do you want to know?
My question was, the closer you are, the closer an occupied structure is to a well pad, the greater the risk. You agree with that?
Not necessarily.
So are you saying that the further away you are from a well pad, it's more dangerous?
No?
Okay, so is it closer to a well pad is more dangerous or further away is more dangerous?
Objection.
He can
This
answer
has
the
answered
question.
both questions.
You can answer
Answer-
the question.
I'd say the way you asked it the first time, you were equating a level of risk or exposure the closer you got, and I don't know that I agree with that.
So again, are you saying that you believe there is less risk the closer you are to a well pad, an occupied structure to a well pad, or less risk if an occupied structure is farther from a well pad?
I think in general, the closer you are to any particular exposure in a life, the more at risk you could potentially be.
How close is a safe distance from an occupied structure to a well pad?
Objection beyond the scope of this witness's testimony.
To the extent you know.
Sure, so DEP has regulations that provide setbacks. And so it's my general understanding of DEP regulations that they take the health and safety of the environment, communities, and workers into account when they're created. So DEP has a 500-foot setback from buildings.
So DEP is a 500-foot setback. That's a state minimum, right?
Right.
Okay. And of course, Range has an interest in keeping that state minimum as low as possible, right?
I'd say Range has an interest in following all applicable regulations.
Is Range interested in keeping that distance, the state minimum distance, as low as possible?
Objection asked and answered.
Overruled. I didn't hear an answer.
Beg your pardon, sir?
Can you answer the question?
Can you ask it again? I'm sorry.
Does Range have an interest in keeping the state minimum or making sure the state minimum is as low as possible?
Again, I'd say Range has an interest in meeting all applicable regulations.
The lower the state minimum setback is, right, as long as it stays low, the more Range can drill, right? You have more space to drill.
Not really sure what you're
It's
asking.
not super complicated concept. If the state minimum is 500 feet,
Right.
right, compared to the state minimum of 2,000 feet, there's more places where you can drill if it's 500 feet, correct? As opposed to 2,000, right?
There would be less restrictions for 500 feet versus 2,000 feet, as you used in your example.
Okay. But now municipalities, they're allowed to set further setback distances than the state minimum, correct?
Objection, calls for a legal conclusion.
Sustained.
And you're aware, you are in a bunch of municipalities in Western Pennsylvania, right?
Right.
Okay, so you're familiar with other municipalities and different ways that they zone for unconventional oil and gas drilling, right?
Generally.
Okay, so there are municipalities that exceed the 500 feet setback, right?
Objection, irrelevant.
To the extent you know.
Are you asking me if there are other municipalities that have stricter setback requirements than 500 feet?
Yes.
Cecil.
Yeah. And other municipalities, right?
I'm not sure.
You familiar with South Fayette's setbacks?
No.
Okay. Are you familiar with any other surrounding municipalities and their setbacks?
Not off the top of my head, no.
Okay. Are you familiar that with the concept of zoning unconventional oil and gas drilling in particular zones as opposed to setbacks? So zoning it maybe in an industrial district or a light industrial district. Are you familiar with that concept?
Yeah, I'm familiar with the general zoning concept, yes.
Okay, and there are some municipalities that limit unconventional oil and gas drilling to industrial zones or light industrial zones. Are you familiar with that? Generally.
I'd say generally, but I couldn't give you any examples.
Talk a little more about some of the risks associated with oil and gas, unconventional oil and gas drilling. So Range is a publicly traded company, correct?
Yes?
Okay. And as such, Range is required by the SEC to file certain annual reports, right?
Objection, beyond the scope of this witness's testimony.
Well, I think I have the right to explore that we're talking about setbacks and the reasonableness of setbacks. And I'd like to explore, he already said there are some inherent risks with unconventional oil and gas drilling. I'd like to explore in more detail what some of those risks are and what they tell their shareholders some of those risks are.
Is this the witness to do it, though? That's what I'm kind of wondering about, because, I mean, his testimony was limited to the application process with respect to applying for wells and digging or drilling permits. I'm just wondering if, we're going beyond something that he knows about. For now, I'm going to let you ask your question, but let's try to move this on with respect to this witness. It is 9 o'clock and we're still on the first witness.
Sure, and to that point, I'd be happy to save this entire line of questioning. If there is a more appropriate witness, again, I know you didn't require witness list exchanges, but I could ask Range if they would answer for me whether there is a more appropriate witness to talk about risks, and I'll save all those questions for that witness.
But I guess the question is, if we could just speed this along. In other words, ask him the question, and if he doesn't know the answer and he's not the witness, then let's move on to the next question before, introducing exhibits and going through various, multiple questions with each witness. Let's find out if he has anything to say about it, and if not, let's move on.
Are you the person who is familiar with filings by Range with the SEC?
I'm not familiar with that.
Okay. I'm going to save this line of questioning for a witness who is more familiar with that.
Okay.
Okay, and I'm also going to save some additional questioning that I imagine you would rule is outside the scope of his direct for the appropriate witness. You turn to Exhibit 4, please.
Okay.
What is Exhibit 4?
So it's on range letterhead and it's labeled Connor Samuel, 130 Grange Road, McDonald, PA, 15057.
What is it?
Appears to just be a general overview of scheduled activity at the Connor Samuel site.
Like, do you know what this document is?
I
Not guessing. Do you know what this document is?
I don't generate this document, sir.
Do you know what this document is? Is this something you come across? Is this the type of document you deal with in your field?
I have seen this before, yes.
Okay. This document?
One similar to this. I can't say that I've seen this exact document.
Okay. Sorry. Please continue, Ms. Moore.
I'm sorry, may I continue?
Yes, sir. Yes,
Okay,
please.
thank you. So, Mr. Matinka, this particular document at the top says schedule as of 1/2/2005. Do you see that?
I believe it says schedule as of 1/2/2025.
Correct. And as you mentioned, this is for the Connor Samuel site. Is that correct?
Correct.
And what is the natural gas development that is listed in this particular update document?
Under nat.
Objection. The witness has not identified this document as something that he generated or is familiar with. And so I think it's inappropriate to ask him to read from the document into the record.
Well, he did just say he was generally familiar with what this document is.
Don't believe that was his testimony.
Well, let's
Respect
ask
to
him.
this specific document.
Are you familiar with this type of document?
I've seen this type of document before, but I don't generate this type of document.
What do you mean by you don't generate this type of document? Like you have nothing to do with the input or what is involved with this type of document?
Correct. I have no input into this document. or
How
this
do you
type
come
of
across this document? I guess, is this document used by you in doing your job for Range Resources?
No, it is not.
Okay. Can we move on from this document then, since it's not something he
You've
deals
never
with?
seen this before, you don't know what it is. Is that what you're saying?
Objection. Mischaracterizes his testimony.
I'm just not clear, and I'm not trying to waste everyone's time here, but I'm not clear, Mr. Matinko's position on this document.
I believe I heard from Mr. Volz that you are to move on.
His position is that he does not use this document in doing his job with Range Resources. So my ruling is that this is not an appropriate document to ask him questions about, since he has no knowledge about its contents.
Mr. Volz, Mr. Matinko has been standing for, I think, an hour and a half. May we take a break so that he can sit down for a few minutes?
Yeah, absolutely.
Been standing for over an hour and
Mr.
a half.
Matinko, would you like a break? Or would you like to continue with your cross-examination?
5-minute break would be nice.
Okay. It is 9:03. Let's come back at 9:10.
no, that's what I just asked him. He said, we'll see. He was trying for 10 o'clock, but I don't think that's.
We hot or cold?
I'm always hot. Ask somebody else. There you go.
You want to sit somewhere. I mean, I can, because this isn't conducive to it, but we can move the. I understand.
All right, we're back on the record. Ms. Moore?
Okay, thank you, Mr. Volz. Okay, so Mr. Matinko, question for some further clarification on the Connor Samuel well pad. When you testified earlier about, you potentially could be stranded, but you didn't think you were currently stranded. I have a question about pipelines and gathering. Who regulates pipelines?
So it depends what aspect you're talking about, but, obviously there's DEP permitting involved with pipelines.
Any other regulatory agencies?
Depends. Could be FERC.
Okay. So FERC would govern pipelines if they're intrastate or interstate?
I don't remember specifically.
Okay. So DEP, maybe FERC. Under no circumstance does Cecil Township govern pipelines, right?
Objection calls for a legal conclusion.
I'm trying
To the extent you know.
Right, I'm not sure.
Yeah, I mean, you've never come to a local municipality to get approval for a pipeline, right?
That wouldn't be me pursuing that.
Range.
Again, I'm not sure.
Are you saying you don't know the answer to that question?
Right.
Now, you said you are an environmental compliance person, right?
Right.
Okay. Are you familiar with the Washington County Hazard Mitigation Plan?
Objection beyond the scope of his direct.
Overruled.
I'm not familiar with the Washington County, whatever you called it.
The Washington County Hazard Mitigation Plan.
Not familiar with that.
You've never seen it before?
No, ma'am.
How about Act 13 of 2012? You're pretty familiar with Act 13, right?
Yes.
Okay. And Act 13 increased a presumption of liability for water supplies contamination. They increased that. It used to be 1,000 feet, and now it's 2,500 feet for unconventional well pads. Is that accurate?
Objection calls for a legal conclusion.
Do you know what the statute says?
Yeah, in Act 13, presumption as it relates to unconventional wells is 2,500 feet.
Okay, thank you. So the presumption for liability is currently 2,500 feet under Act 13, correct?
Right.
Okay, so that means an operator is presumed responsible for water pollution if the affected water supply is within 2,500 feet of an unconventional well pad, right?
Can you state that again? I'm sorry.
An operator is presumed responsible for water pollution if the affected water supply is within 2,500 feet of an unconventional well.
I believe there are some other requirements, not just as you've stated.
But you are familiar that there's a presumption of liability if you're within 2,500 feet of a water supply, if the unconventional well is within 2,500 feet of a water supply, correct?
Objection asked and answered.
Sustained.
We'll move on. So let me just summarize some of the things I think you were able to testify to. Okay, Range currently is operating 5 well pads in the township, right?
Objection asked and answered.
Overruled.
These should go really quick. Range is currently operating 5 well pads in the township, right?
Range has 5 well pads in Cecil Township, yes.
Okay. And you're actively drilling. I think you mentioned Connor Samuel. At least on one of those well pads, you're actively drilling, correct?
Yes.
Okay. And the township hasn't told you to stop, have they?
Not to my knowledge.
Okay. You didn't get a letter from Miss Ross over here, right?
Wouldn't come to me, but I'm not aware of one.
Okay, not aware of it, great. And you can site a well pad outside of Cecil Township and access oil and gas rights underneath Cecil Township, right?
Hypothetically, yes.
Okay, wonderful. So how have your or Range's operations been directly, immediately, and substantially impacted by Ordinance 9, 2024?
I'm sorry, could you restate that, please? I didn't hear all of it.
How have Range's operations been directly, immediately, and substantially impacted by Ordinance number 9, 2024?
Objection calls for legal conclusion, also outside the scope of this witness's testimony.
To the extent you know, you can answer the question.
I don't think I can answer that question.
Because you don't know?
Right.
Okay, great, thank you. I will pass to Mr. Brown.
Mr. Ferguson?
I'll make things fair. I'll stand up. I'm also a Ringgold graduate.
Right.
Not many people say that in public, but I'm proud of you for bringing that to our attention. I also wanted the board to know that Mr. Josh Stonemark is here this evening. He was working, so he's been able to make it here. So I believe that you said earlier that it's your understanding that Ordinance 9-2024 prohibits drilling in Cecil Township. Is that your understanding?
No, not as you stated it.
Okay. Fair enough. So when you are the Vice President of Environmental Compliance, right?
Yes.
And what is the scope of your duties so that when I ask you questions, I'll make sure to stay within the scope of your testimony and your duties?
Sure. So, as I stated earlier, my team oversees environmental compliance and training of other employees at Range. So operational folks, engineering folks, we educate them on requirements for the areas that we operate. We also have staff that perform lots of reporting functions, assist other Range employees to ensure that they're meeting different compliance obligations. Also, my group conducts inspections of our activities, whether we're drilling there or otherwise, so our well sites and other activities. Again, we function as the primary point of contact for the PAD.
Okay. So when it comes to zoning regulations, that's not your area, is it?
It's not.
Okay. And would it be fair to say that if I direct your attention back to Range's exhibit number 7, which is a 19-page document, that's the authorization of coverage under the Erosion and Sedimentation Control General Permit for Earth Disturbance associated with oil and gas exploration, production, processing, or treatment operations or transmission facilities. This, by and large, sets forth 19 pages of responsibilities that an operator assumes in connection with erosion and sedimentation control, earth disturbance, protection of streams in connection with oil and gas. Is that a fair general summary of this document number 7?
Yeah, that's a fair general summary.
Mm-hmm. And that's really what you're hired by Range to oversee, the compliance that is required and described generally in this exhibit number 7. Is that fair?
Yeah, that's one of my duties and my
Okay.
group's duties.
All right. And in Exhibit 8, looking at that, the application there, I'm not seeing anywhere on it, Exhibit 8, where it actually asks you to identify who owns the land. Did I miss something, or does that particular document not require you to identify who owns the land?
You want me to read through this right now, or what?
You don't have to read through it, but is this a document that, since your counsel asked you about it, is this a document that you oversee the completion and submission of?
No, that's handled by our regulatory group.
By the what?
By our regulatory group.
Okay, all right. And so, at what stage do you become? At what stage of the development of a well site do you become involved? In other words, when do these environmental compliance questions arise, and you become involved?
I'd say in general, it's once we start to move forward with development of a well site or a well. So my group does not obtain the ESCGP or the well permit. But once construction begins at that well site, my group then performs a lot of the functions of the conditions of that document we looked at in the last exhibit.
Okay, all right. So, in other words, you've got a regulatory compliance group within Range that would submit this paperwork, and then once you get the permit, then you and your team become involved to observe the operations to make sure they're in compliance with the permits. Is that correct?
Yeah, that's one of the functions of my group.
Okay.
Yes.
But not really the application part of it.
The filling out of the application?
Yes?
So my group does not fill out these particular applications, no.
Okay. And in connection with our being here tonight, you aren't here to testify about the environmental conditions or compliance in connection with any particular piece of property in Cecil Township. Is that correct?
Sorry, can I have that back again, please?
Could you read that back to her? She seemed to have missed it.
Question, in connection with our being here tonight, you aren't here to testify about the environmental conditions or compliance in connection with any particular piece of property in Cecil Township.
You understand the question?
Yes, I was just waiting for further instruction to make sure this was,
It is. Please answer.
okay.
He just wanted to make sure that we all understood what the question was.
Yep, I'm trying to follow the rules here, so.
Okay?
So can you restate it one more time so I can answer it, please?
Yeah, that's fair. It's fair. The question is, your testimony tonight about environmental compliance generally, it doesn't apply to any particular parcel of land in Cecil Township. Any particular site, any particular development site. You're not here to tell us about environmental compliance on a particular site in Cecil Township. Is that correct?
I believe the questions that I've answered, some have been specific to sites in Cecil Township. I was asked what the 5 pads were. I was asked about activities at Connor Samuel.
But when your counsel examined you, she was asking you about your responsibilities and about these forms which were made of exhibits, but not about the plans of Range Resources in connection with a particular parcel of land. Is that fair?
I mean, I think I answered questions about pads that are existing in Cecil Township.
Okay, I'm going to move So does range typically, if you know, does range explore the feasibility of a well pad before signing leases? If you know.
Yeah, that's outside of my area of expertise. I'm sorry.
Do you, Attorney Moore was asking you a little bit earlier about sort of the levels of the process of well pad development. Setting aside that, do you know from the time that a lease is signed to the date that fracking occurs, do you know how long that period of time typically is?
I think that can vary greatly, and I don't have an average, no.
Okay, if you don't know, that's fine. You have nothing to do with signing, you have nothing to do with the process of procuring signatures on leases by landowners. Is that fair?
I have no involvement with that.
Okay. So the ordinance which Range is challenging tonight, that's one of your exhibits. Which one it is? That's exhibit number 2. So if you'll turn to, it's subpart 5, called Setbacks and Siting. Right, the pages aren't numbered, so I can't tell you what page it is, but it's section 1. C5. Right in the middle of the page, it says number 5, setbacks and siting. Tell me when you have it.
I see that.
Okay. So the regulation, which is B here, it says the nearest edge of the well pad shall be located not less than 2,500 feet from any protected structure. Okay. So if we look at your exhibit 7, and we turn to page 5, there's a definition of well pad there. Now, when you estimated your well pad to be about 3.5 acres, does the definition of well pad appearing on page 5 of 19 include all of the items that you were including when you described a well pad as being 3.5 acres? You see the definition of well pad?
Yes.
Okay. And is that description of a well pad, just for the record, it says the area surrounding an oil or gas wellhead that is subject to earth disturbance and that is used or planned for the use of drilling, production, or plugging of the well, including associated support activities such as storage of chemicals, wastewater, drill cuttings, and equipment, but it doesn't include roads, pipelines, and facilities for withdrawal, storage, and conveyance of fresh water. Is that the concept of well pad that you had in mind when you described a well pad as being 3.5 acres?
Yeah, I think that's consistent.
Okay.
Because you would only use the well pad that I described, that would be 3.5 acres or so, for drilling, production, or plugging of the well.
Mm-hmm.
Use any of that other
Okay.
non-well pad area for any of those activities.
Okay. But also in this definition, in the beginning it says the area surrounding an oil or gas wellhead that is subject to earth disturbance and is used for those purposes. So the area of earth disturbance for purpose of, let's say, leveling the well may be larger, correct, than the actual location of the facilities described in this definition. Is that right? You understand my question?
I see the use of the word earth disturbance in that definition,
You
yeah.
understand my question? I'm asking you, do you agree that oftentimes, especially here in western Pennsylvania where there's no level land, that the area of earth disturbance may be significantly broader than the area, than the part that is used for drilling, production, plugging of the well, associated support activities, storage of chemicals, and so on?
Yeah, I think that's exactly what I testified earlier.
I'm just asking, okay, all right. So you agree the area of earth disturbance may be larger than the location of the facility supporting the wellhead, is that correct?
Yes, and I may have referred to it as a permitted area when I said an average disturbance or permitted area of 15 acres or so.
Okay. Now, if you go back to the ordinance which is being challenged here, that once again is your Exhibit 2. I'd like to direct your attention to the second page where there's a definition of drilling site or well pad or pad. Let me know when you found that.
I got it.
Okay. And it says, an area which includes the perimeter of the surface area of drilling operations. Can you see a distinction between the definition that is used in the ordinance, which is being challenged, as opposed to the definition of well pad, which appears in your Exhibit 7?
I object. The reference to Exhibit 2 is beyond the scope of the witness's testimony.
Yeah, this is in
Overruled.
federal court. The rules of
Overruled.
civil procedure don't apply. And
We're
it's
good.
overruled, so.
We're good. You can answer the
Okay.
question.
Do you understand the question? The distinction between the definition in the ordinance versus the definition that appears in the DEP materials.
If you're asking me if they're different, then yes, they're a different definition.
How are they different?
Guess I can just read them both to you if that's what you're looking for.
Well, I know they have different words. We all know that. But substantively, how are they different?
Objection calls for a legal conclusion.
Well, this is in his area of expertise.
You can
That's-
answer the question.
Again, they both have literal different definitions on one page to the other. Not sure what conclusion.
Yeah,
you're
we
trying
know
to-
that. Do you know what the differences are? I'll help you out here. Can we agree that under the ordinance, a well pad is just the perimeter of the surface area of drilling operations, whereas the DEP's definition goes on to say, including associated support activities, such as storage of chemicals, wastewater, drill cuttings, and equipment. So can you agree with me that the definition, the ordinance of a well pad, is narrower than the DEP definition because the definition that's in the ordinance does not include associated support activities. It only includes drilling. Do you agree with that?
Again, I agree that they're different definitions.
Do you agree with
Yes.
what I said? We know they're different definitions. We can show what words are different. I'm asking you to think about it. And as you understand what a well pad is, because your counsel asked you about it, and everybody's asked you about it, and you know what a well pad is, can we agree that the definition within the ordinance, which is only about, is the perimeter of the surface area for drilling operations, is narrower than the definition that you apply under the DEP, which includes associated support activities? Do you agree with that?
Yeah, the way you summarized it seems accurate.
Okay. And then if you'll go back to the ordinance, right where we were reading before, section 5B. So we measure 2,500 feet from a well pad, more narrowly defined than the DEP defines it, from a protected structure. Now, if you go back to the definitions in the ordinance, we have a definition of a protected structure. You see that? It's in the fourth
Yes.
page? Okay.
Yes.
And that's limited to occupied residences, commercial businesses, religious institutions, or other public or private building used for similar uses. That's the first part. So there's lots of other kinds of buildings in Cecil Township, are there not? There are industrial, manufacturing buildings that are not occupied residences, commercial buildings, or religious institutions. Do you agree with that?
Yes.
Okay. But that's not all. They have to be impacted by noise, emissions, light, or other negative attributes of drilling operations. So can we agree that there's at least an attempt to narrowly confine the types of structures to which this 2,500-foot setback applies?
Objection beyond the scope of this witness's testimony.
You can answer to the extent you know.
Say that based on the definition, there appear to be some details, I guess, that the ordinance attempts to define.
Okay. All right. Now, let's go back to your Exhibit 7. I think it'd be fair to say from your direct examination that the DEP imposes rigorous compliance requirements if you're going to disturb the land or affect streams, is that correct? Or build a well pad?
Yes, DEP has strict regulations and requirements, yes.
Okay. So if I look on page 2 of 19, there's a reference, there are several references throughout to the Clean Streams Law. Now, as the Vice President of Environmental Compliance, are you familiar with the Clean Streams Law? Yes?
Yes.
Okay. And in fact, later in this summary of the requirements, you actually have to have people who are inspecting to assure compliance with this Clean Streams Law. Is that correct?
Among other requirements, yes.
Right? And you even oversee those inspectors, don't you?
Yes.
Okay. So what are you looking for? What are the risks that you are looking for in overseeing inspectors to assure compliance with the Clean Streams Law? That's right in your wheelhouse, isn't it? Because you oversee those people, don't you?
Yeah.
All righty. So tell us, what is it that you're looking for?
So I'd say at a high level,
Did you say eye level or high level?
high level, I'm sorry.
Eye level?
High.
High level. Okay, thank you.
So at a high level, if you want to look at extremes,
Oh, I do.
yeah,
Go ahead.
the inspectors would be ensuring that there's no impacts to waters of the Commonwealth.
Well, what kind of impacts could there be from fracking?
I'd ask that the witness be allowed to finish his answer to the question.
It's a
before
fair
another
point. He
question
was
is asked.
mid-sentence.
Okay, go ahead. Please finish what you were saying from the high level.
Sure. So I just want to clarify, though, we were talking about earth disturbance type activities, and then you pivoted to fracking, which is very different. So I guess you could clarify how you want to frame your question.
I want you just to complete your answer. And I did ask you, what were the risks that you were inspecting for? You could just finish that answer.
Sure, I don't remember the word risks being included with the question, but in general, my inspectors would be looking for compliance with applicable regulations and permits. So from an earth disturbance perspective, they're ensuring that construction sequences are followed, that erosion and sediment controls are in place and functional and being maintained, that stormwater controls are properly in place when the time is right, maintenance of said activities when operations are going on at a well site. They're looking for containment practices, waste management practices, ensuring the proper paperwork is on site, things are reported to the DEP as required. The list goes on.
Okay, so So now we'll come to a slightly lower level, okay? So you mentioned that the erosion and sedimentation controls are in place and functioning, is that right?
That's one of the items that we verify, yes.
Okay. What happens if the erosion and sedimentation controls are either not properly in place or fail?
Can you be a little more specific, what you mean?
Well, this is your business, but yeah, what happens if there's a failure resulting in erosion or the leakage of sedimentation? What are the consequences that you're trying to prevent?
Sure. So, obviously, rain events can move sediment. I mean, that's the general basics of what's going on here. So after rain events, my inspectors will walk the sites looking for damage that may have been sustained following those rain events. If there's maintenance that needs to be performed, that's done. We help to coordinate contractors to do said maintenance. We make notifications to the DEP if certain conditions are met that are right in the ESCGP requirements. We work with the DEP inspectors to make repairs if needed, or
Yeah, I was asking about the risks. What are the risks that are trying to be averted by that?
I'm asking that the witness be allowed to finish his answer before another question is asked.
Yeah, he wasn't really answering my question, though.
you
Understood.
literally asked
So,
what happens.
Time out. Time out. Let's not do this back and forth. Mr. Ferguson, please ask your question.
Yeah, what are the consequences of failed erosion and sedimentation control systems?
So obviously there's going to be different levels of failure. You know, someone can deem not maintaining something immediately as a failure, but that doesn't equate to any kind of actual environmental damage. So,
Let's talk about the environmental damage then.
okay.
What's the potential environmental damage as a result of non-compliant or a failure in the erosion and sedimentation control systems?
Sure. So sediment-laden water could end up in waters of the Commonwealth. There could be accelerated erosion. Could ultimately lead to siltation in streams.
Okay. Tell us about the waste management. Your overseeing of waste management. What wastes does this refer to?
Sure. So I have staff that perform waste reporting functions. So reporting to the state, handle disposal of drill cuttings, other used items from the site.
Okay. Does it go from both drilling all the way through fracking?
Yeah, there are waste requirements for all phases of well development activities.
Okay. Is that an important function?
I believe that all of our environmental obligations are important, sir.
Okay, well, convince us. Tell us what happens if the waste is not adequately disposed of or controlled. What happens to the environment?
Objection. There's no foundation for this question. It's a hypothetical, and it's totally irrelevant to Range's challenge.
Overruled, you can answer the question.
I guess you're asking me to, in some way, quantify what would happen if, you know, there's a wide range of things that could be considered. Let me start that over.
You understand my question? First, you don't have to guess what I'm asking you. If you don't understand it, I'll just ask it again.
You can ask it again. That'd be helpful.
So you talked about waste management. So first of all, what's the type of waste that you and your team oversee the proper management and disposal of? What are the types of waste?
Sure. It could be drill cuttings. It could be water. It could be spills to the ground where material's cleaned up. That's handled as waste.
When you
Those are
say
some
water, you
examples.
don't just mean
Produced
stormwater.
water.
I'm
Produced
sorry?
water. Produced water.
Produce water?
Produced water, yes.
Produced water, okay. Is that water that's used in fracking or in drilling?
Could be, yes.
Okay. And why is that considered waste? What are its characteristics that make it waste?
Basically, DEP's rules consider almost anything that's not fresh water waste.
Okay. All right. And so what are the consequences if this isn't properly managed? What can happen to the environment? That's your field.
Again, I think this is where we were starting to get a little off track before, because you're saying
Just
if
answer
it's
the
not
question.
managed.
Just don't
right.
direct traffic. Just answer the question.
I'm trying to answer your question, sir.
Try harder. The question is, what happens when that waste is not properly managed to the environment?
Give me an example then.
You don't know
Sir,
of any examples.
Hold up.
Oh.
To the best of your ability, please answer his questions, which is, what damages are you trying to avert with your waste management system? What happens if there is an accident? So,
I guess the reason I'm asking for this clarification is because, there's a wide range of what I would consider waste management obligations. There's paperwork obligations, which if a piece of paper isn't filled out correctly or is filed wrong, there is zero risk.
That's right.
Or
So
damage.
that wouldn't fall within my question, because I was asking about damage to the environment. So if you don't fill out a piece of paper, probably isn't damage to the environment. So I'm asking you, what are the harms that your inspections and your oversight prevent to the environment?
Right. So it could, if material is spilled onto the ground and not remediated, then it could result in soil contamination.
Okay. And you were asked previously about the zone of culpability, right? So if it gets to 2,500 feet from the wellhead, then range would be strictly liable for that. Is that your understanding?
Objection mischaracterizes testimony.
No, I'm not characterizing his testimony at all. I'm asking about his understanding of that regulation, which he seems to be familiar with.
Objection. I believe that question previously was objected to and sustained, if my recollection is correct.
Are you familiar with the zone of culpability?
time out.
Oh, just
So,
asking.
I don't believe that was objected to, or if that objection was sustained. I believe the question was, and the applicable regulation is, if there is contamination within 2,500 feet of a home, Range Resources is strictly liable. Is that?
No, I see. You're mixing a few
So,
regulations and requirements here. What was asked about originally was what's the concept of presumption,
yes.
and that has to do with distance and time factors related to pollution of a water supply. I guess hypothetically that could be affected by some sort of surface release, but that's really not what that's aimed at addressing. That regulation creates the concept of presumption, where it places the burden on the operator to make a case that this alleged pollution was not caused by the operator's activities. So there are timing and distance factors that go into that. So we're kind of mixing a couple topics here. I'm willing to answer anything, but I just want to be clear about what's actually being asked, because we're shifting from a couple topics.
Okay. So is it fair to say you are familiar with these well pads that are shown on the township's map of the well pads? You're familiar with those?
Yes, I'm familiar with ranges. I know if that's the same map, there were a few that are not range pads, but I'm familiar with the range pads that are on that map.
Okay, so as the Vice President of Environmental compliance, do you have reason to know the scope of the horizontal bores of the respective pads?
What do you mean, do I have reason to know?
Is that something that you know about within the scope of your duties as the Vice President of Environmental Compliance?
I'd say in general, yes.
Okay. So, so if we look at the Augustine George pad, do you know whether or not any of the horizontal well bores go outside the Cecil Township municipal boundary lines?
I don't know off the top of my head, no.
If I ask you that with any of these, would you know?
No, sir.
Okay. So this drawing has a scale on it. Sorry. And it is an inch here is 1,000 feet. Okay. And you said that a horizontal well bore could go up to as far as 20,000 feet, right? So if you look at, it's probably less than an inch from the Troyer Space Management Unit 10H to the Chartiers Township boundary line. Do you know whether or not any of those horizontal well bores extend into Chartiers Township, seeing that the distance is probably about 1,000 feet?
Can I have that question back, please?
So this drawing has a scale on it, and it is an inch here is 1,000 feet. Okay, and you said that a horizontal well bore could go up to as far as 20,000 feet, right? So if you look, it's probably less than an inch from the Troyer Space Management Unit 10H to the Chartiers Township boundary. Do you know whether or not any of those horizontal bores extend into the Chartiers Township?
Period.
Seeing that that is probably about 1,000 feet.
Sure, I don't know specifically, but I'd say it's reasonable, but I would caution you that that's an older pad, and so the technology wasn't there to go to that 20,000 feet that you're referencing.
The technology was certainly there to go beyond 1,000 feet, though.
Yes.
Okay. Do you know whether or not, let's see here. The FEHL, permitted fail unit well, do you know whether or not any of the horizontal well bores go into Chartiers Township there, seeing that it seems to be less than 2,000 feet from the Chartiers Township boundary line?
Again, sir, I have never heard of the fail unit well. That is supposedly,
You're not familiar with that one? Okay.
to my knowledge, that's not a well site.
Okay. Are you familiar with the Engel unit well pad?
Yes, I am.
Do you know whether or not any of the horizontal well bores go into Chartiers Township or Mount Pleasant Township?
I don't know off the top of my head, no.
Would it be safe to say that any of these that is a range well, that we could safely presume that there would be well bores in every direction?
I guess, I don't know what you mean by every direction.
North, south, east, west? They're not linear, right? The well bores are not just going in one direction, is that right? The intention is to have a well going out like wagon wheel spokes from the well bore. Is that from the well pad? Is that correct?
No.
Okay. You're saying that they don't go out like wagon wheel spokes in every direction.
They do not.
Is that the intent that they should?
My knowledge, no.
Okay. So, so how would you describe, I mean, within the location of a well pad is a unit, right? The well pad is within a unit, right? And the intention is to extract all of the gas within the unit? Or don't you know the answer to these questions?
Just the way you're asking, it's a little odd. That's why I'm struggling to answer you, sir.
Okay. That's all the questions I have. Thank you.
Thank you.
Johns. Hi, Mr. Matinko. I have a few questions about gathering systems. You recall you had a discussion with Ms. Brown about gathering systems connected to the Connor Samuel well pad. Is that right?
Generally, yes.
So, just to start very basic, right? Gathering systems, this is essentially a collection of pipelines, right?
Yes.
With some above ground facilities, maybe booster stations, things like that.
Right.
Okay. And they generally take the gas from the wellhead and then transport it where?
So it depends. If it needs further processing, then it might go to another location for processing, such as a plant, or if it's of pipeline quality, then it could be sold.
And is there generally one system, gathering system, associated with one well pad?
So a portion, are you asking if a segment goes from a pad all the way to a processing plant or a sales point, or if they combine at some point?
Do they combine at some point?
It could.
They could. Is it generally the case that the gathering system components associated with a single well pad are going to be connected to each other in some capacity?
Are they going to be connected to another pad? Is that what you're asking?
To other components of the gathering system?
I'm sorry, I guess I'm not following exactly what you're asking.
That's okay. I suppose the question's getting a little bit into semantics. When you talk about a single gathering system, is that a single system that's designed to function, do this gathering function for wells at a single well pad?
So there are going to be portions of the gathering system that are only for a particular pad, but then there are going to be other portions that might be servicing more than one well pad.
Okay. But is it generally true then that all of the portions of a gathering system that serve one well pad, those are all part of the same system?
Sorry, could I have that back?
When you say same system, can you be more specific?
Well, I guess I'm trying to get a little specificity from you as to what constitutes a single gathering system. How would you define where one gathering system ends and another begins, or where it ends and then you move to the next phase of sort of the process flow?
I think that would be me defining it kind of based on my understanding, not really a specific citation.
No, that's fair. If there's not a clean answer, then we can just move on. At the Connor Samuel well pad, are there any components of a gathering system that are installed there now?
So that's not part of kind of my jurisdiction, so I'm not sure if that's going to tie into another portion that's already in the ground or not.
So you did testify earlier in responding to questions from Ms. Brown, though, about the need for there to be a gathering system in order for Range to take advantage of wells it would drill at the Connor Samuel well pad.
Right, generally that would need to be there, yes.
So what I'm asking is, at the Connor Samuel well pad today, are there any components of the gathering system that have been installed there?
Not to my knowledge.
Okay. Do you know whether, and I believe you said it is another company that actually constructs and operates the gathering system, is that right?
That's right.
It's generally Mark West around here, is that fair?
For a good portion of the field, yes.
So, well, do you know if the company that would own and operate the gathering system, has it obtained any approvals from the county for any component of that gathering system?
I don't know the answer to that, sir.
Okay, and do you know whether it's received approval from any other regulatory agencies for that gathering system?
I do not know.
Or any component of that gathering system?
Fair enough. I don't know.
Do you know whether any construction has begun on any components of a gathering system that would serve Connor Samuel?
I'm not aware of any.
Okay. And so then if it has begun, you don't know whether it's continued diligently since it was initiated?
Right, I don't know.
Do you know whether the company, the gathering system company, has committed any resources towards gathering system components that it won't be able to get back?
I don't know.
Okay. And I'm assuming then you don't know whether the gathering system company has also requested an opinion from the township zoning office as to whether or not it can proceed with plans to install the gathering system.
I'm not aware of that.
Okay. I think that's all the questions we have.
Thank you.
Apologize, I misplaced my sheet. Bernard Matthews. Okay. Ms. Brown, any redirect?
No redirect, thank you.
Okay. It is 10:04 p.m. How many more witnesses do you have? And would you like to get started tonight, or would you like to recess until next month?
We'll recess until next month.
Okay. We planned on ending around 10 o'clock anyway, so with that, would you like to do a motion to?
Mr. Bolts, if I could just make one clarification for the record. I think when you were announcing the parties to the case and the council that represented them, you may have mentioned Sarah Martic would be participating and being represented by Ethan Story as an independent party.
Yes.
I think it was not her intent. She is the executive director of Center for Cultural Justice.
Okay.
And did make a statement in support of that group, but I do not believe she intends to participate as an individual.
All right, well, thank you for the clarification. Yes, sir?
Could I ask one more question? To know whether we prepare for the hearing in March to present our own evidence, how many more witnesses will Range Resources be planning on presenting?
Is that a fair? Yeah, that's a fair question, just so we can schedule this. Because, and remember though, when Range is done, we agreed to recess and give the objecting parties until the following hearing to present their case. So even if Range finishes tomorrow, or not tomorrow, next month, we will recess and give your side time to prepare. Ms. Brown.
So, I'm sorry, Mr. Volz, was there a question?
I think before I corrected myself, the question was how many more witnesses do you have were you planning on presenting?
It may change, but we're currently planning 2 more witnesses.
All right, thank you very much.
And Mr. Volz, I think there was a decision, there was an agreement by council to exchange names in advance of testimony, but then there was a disagreement as to whether or not all council needed to disclose their witnesses. And I think that Mr. Volz came back after executive session in January and indicated that there would be no exchange of witness names that would be required. I will say that, you know, I'm amenable to council agreeing to something where all parties have advance notice of witnesses. But I think a unilateral request for only Range's witnesses when there is no additional corresponding benefit to Range is unfair.
The parties can make an arrangement amongst themselves if they want to share witnesses
And
lists
I'm
ahead of
happy
time.
to do that with an equal advance notice.
All right. With that, we're going
Mr.
to.
Volz, may I ask one question? With regard to the pending motions to dismiss, are you planning to have briefing at the end of the presentation of all evidence, or because Range will be submitting briefing, but I want to know what your expectation is with regard to receipt of
The
that
current plan is to have Range Resources present their case, and then the objecting parties present their case, and then propose findings of fact and conclusions of law that will address, among other things, the preliminary matters along with the merits as to whether the zoning ordinance is exclusionary.
So all the motions that have been filed to date, plus party status and the substance of the challenge.
Correct.
All on after testimony has been concluded.
That's the current plan, yes.
Okay, thank you very much. I appreciate clarification.
Can I please?
Absolutely.
Last thing for tonight, for the board's consideration, Ms. Brown talked about, and you talked about completing the entire case and then moving on to findings, but if I could add a step in there, or ask the board to consider a step, that is after Range closes its case in chief, should it fail to offer any evidence in support of the standing argument, could we actually brief and argue the standing and rightness issue at that time before then proceeding into the township's case and the case of every party on this side? So it's their burden to demonstrate standing, ripeness, all those jurisdictional issues. After they put in their case in chief, if they fail to do so, can we argue it and have that decided at that point?
Yeah, I mean, the problem with that would be is that they would finish their case in chief, right? And then we'd have a briefing schedule, which would be more than somewhere around 30 days. And then we'd have so that would just push it out for another 2 months just to decide that. I'll discuss it with the board, but I think the better plan is to everybody present their case, and then we'll make a ruling on jurisdiction. If we come up with a ruling that we don't have jurisdiction, the case might end right there, and we might not get into the merits. But, from a timeline perspective, I think the board wishes to proceed with everybody putting their cases in chief on in full, and then we'll roll on the various issues as they arise.
I wish there would be consideration of that, because that's really
There has been, Mr. Ferguson. I mean, it's been raised last month.
That's
And
kind of the antithesis, is to hear a case and then decide whether you should have heard the case. And it's very wasteful. And so tonight, for example, it doesn't appear that Range's expenditure of this entire evening with a witness had anything to do with establishing their standing in any respect whatsoever. And so I think the board should have an interest in its statutory compliance to make sure that what it's doing is sanctioned by state law and that you have the jurisdiction to do it. So we hope that we can get to that, not at the very end of as many hearings as we have, but when it's apparent that the issue can be adjudicated.
so noted. Thank you.
I know you're not enjoying yourself here either. I mean, I know you don't want to be here more than necessary, but there's a way to achieve that.
And I would just note for the record, I take issue the fact that Range took up the entire evening. Fact
We
is
don't need
not
to do this
true.
tonight. I mean, I appreciate you both of you representing your positions, but some of these comments aren't necessary. The board's going to stick to the facts and do its best to come with a just and quick decision. The comments among council is unnecessary. So thank you very much. Mr. Gump, would you like to do a motion to adjourn?
I'd like to make a motion. I'm looking for a motion to adjourn this evening's meeting.
I'll make that motion.
All in favor?
Aye.
Meeting is adjourned. 10:10 p.m.
The next hearing will be the third Monday in March, which I believe is also March 17th. March 17th. At 7. What's that?
Thank you. realize that's biased, but we appreciate it.
Well, no, it's not. I consider myself very unbiased, so I think you guys were just fantastic. Good trying. Thank you.
I'm supposed to pay